Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And my brothers and sisters, what I'm about to show you, I can't make up. This is coming from the 10th Circuit out of Colorado around the 18, 19, and 20-year-old bans that was overruled as unconstitutional. An Obama-appointed judge just made the argument from the Bruen decision that only white people count in the people, so therefore should only white people have guns. I'm not making this up. Everything will be linked into the description box below, and this shows you how far they are willing to go, as we've seen in multiple other cases, to get their gun control. Make sure you spread this one out. Make sure you send this one everywhere. And of course, make sure you hit that like button, subscribe to the channel, and turn the notification bell on, because we are passing freedom on the daily, and we'd love to have you along for the ride. And make sure you guys are not missing out on the limited time design shirt that I put together with 9line. It's on the screen right now. It is the Liberty versus Tyranny shirt. That tree of liberty sure has been thirsty recently. Well, here's the actual breakdown. You've got from canopy to trunk to actual roots, all the characteristics which lead to either freedom or they lead to complete tyranny and control. That's why we put this shirt together. It's linked right down there in the description box below, and there is nothing that says you can't look amazing and have an exclusive shirt that's limited time design while you push our gun rights forward. So check it out right down in the description box, and I'd love for you guys to take part in that so you guys have a shirt that no one else has. Now, as I said in the introduction, we've got to hit this, guys, because you can't make it up. Okay. Let's take a trip to the 10th Circuit. This is in Colorado, all right? Colorado urges 10th Circuit to reinstate the age cap on gun purchases. Now, the group Rocky Mountain Gun Owners sued Colorado to block a new law raising the minimum age to buy a gun to 21 years, and it got stuffed. Now, if you guys will remember, last year we covered it. It got smoked because it is unconstitutional. Why are 18, 19, and 20-year-old adults not considered adults to have their gun rights? Can they vote? Yep. Can they go to war? Yep. Can they enter into contracts? Yep. Can they have mortgages, houses? Yep. But when it comes to gun rights, that's different, though, because they're not that level of adult. It creates a different class of people amongst the people, and that's the point. But speaking of the people, wait until I show you what the Obama-appointed judge just said. All right, let's keep going, because as always, there is a complete and total quest to undermine the Bruen decision, which wrecked their faces from across the nation. Denver, Colorado. Colorado urged the 10th Circuit on Tuesday to reverse a lower court's injunction of a law that raises the minimum legal age to purchase a gun to 21 years old. It's unconstitutional. It should be struck down. The state appealed after Chief U.S. District Judge Philip Brenner, who was appointed by George W. Bush, granted a preliminary injunction that blocked the law from going into effect on August 7, 2023, and the 10th Circuit declined to lift the injunction during the appeal. We've covered all of this. But here's where it comes forward. This is where the rubber meets the road, where the meat hits the cleaver. I don't even know another analogy. This is where it gets real. Check this out. The plaintiffs, Zero Compromise Second Amendment advocacy group Rocky Mountain Gun Owners, and two individuals sued Colorado Governor Jared Polis, a Democrat, in April 2023 after he signed the law. Rocky Mountain's argument relied on the Supreme Court's decision in the Bruen decision, which cautioned the government against restricting the right to bear arms and recommends looking to history for guidance. Now, if you're not familiar and you don't have it off the top of your head, they were told to look for history, text, and tradition. So you had to have historical analogies, you had to have the text, and you had to have the tradition of gun control for it to be constitutional. That was the whole thing. The big problem is there wasn't any because it's not the way that it was written. But that's where the gun controls are struggling. That's why you've seen in the tactical machining case when they argued, the government, the ATF, the United States government, argued the fact that since they discriminated against Native Americans and Catholics in the past, it's perfectly fine to discriminate against the people now. Actually happened. Tactical machining case. Look it up. We covered it on this channel. And there's been many other examples of racism being used to defend government laws. But let's continue because for some reason the media doesn't want to cover that. It's weird, but let me show you what the Obama judge said here. This is the payoff. As Colorado presented 320 pages of sworn testimony from 4 experts who offered a historical backing and a rational basis for the law, U.S. Circuit Judge Carolyn McHugh pointed out that historical analysis falls second to Bruen's first step. Quote, if I'm reading Bruen correctly, perhaps I'm not, first comes the understanding of the people, then the historical analysis. So she's saying the definition of the people, and then you look at historical analysis. So she's basically adding in another step here. The Obama-appointed judge pressed Stevenson on whether the court should adopt an originalist view of the people as adopted in the 18th century. Here it comes. If you take the people at the founding of the country, that means only white property owners have the right to bear arms, McHugh said. In that case, McHugh pointed out, neither she nor Stevenson would be allowed to bear arms today. What? Okay, so just to give you guys a backed out macro view of what's happening right now. You have an Obama-appointed judge who just said, well, if you're looking at the Bruen decision from the Second Amendment through an originalist perspective, then you should probably have to look at the people through the originalist perspective. And we should get rid of all the progress we've made to get more human beings into the people. So therefore, only white people and landowners can own guns. In fact, fellow prosecutor or arguer or defendant or plaintiff, you and I wouldn't have guns either. That is neither here nor there, and it has nothing to do with what we're talking about, but they're trying to inject race and the originalist view of the people before we made progress forward, and they're trying to tie it into the Bruen decision to make the Bruen decision seem like it's a problem because they can't focus on the part that there was no historical context for gun control. So now they're bringing in even more examples of racism and emotional injection and fear in order to get them going forward. Oh, doesn't it make sense? Because if we look at it this way, which, by the way, is not their job. The Bruen decision came from the Supreme Court. They're not the Supreme Court, the 10th Circuit. Then we wouldn't be able to have guns either. So, you see, there's really a problem in that first step of the people. She's trying to redefine the people as the same originalist interpretation of the Second Amendment, which is a completely separate thing. This is the lengths that they are willing to go to. But let's continue. I got one more thing for you. Actually, two more things. As a group, the panel worked to parse out what states can and cannot regulate. Senior U.S. Circuit Judge Michael Murphy, a Clinton appointee, asked Stevenson whether Colorado could prohibit everyone from purchasing a gun. Judge McHugh quizzed Arrington on whether states legally could prohibit 5-year-olds from purchasing firearms. Okay, so we've gone from the people in the originalist view, only white people and landowners, from an Obama-appointed judge. Then she chimes in again that says, well, can we prohibit 5-year-olds from buying guns? The level of stupid is really impressive. Let's just address really quickly that little nougat. 5-year-olds aren't legal adults. 5-year-olds don't have the ability to have their rights in the exact same way that an adult does. A 5-year-old can't vote either. They can't enter into contracts because they're in the age of minority. When they become an 18-year-old and a majority, they get the rights of an adult. So an Obama-appointed judge has now said it's white people and landowners, if we look at the Bruen decision through the originalist perspective of the people, which is not the conversation. And now she's asking us, well, can we restrict 5-year-olds? This is a judge on the 10th Circuit. Good Lord, the level of stupid. One more thing. Colorado lawmakers argued that raising the age to buy guns reduces homicides, accidents, and suicides. Absolutely not true. U.S. Circuit Judge Richard Federico, who was appointed by President Joe Biden, asked why that doesn't throw the question in Colorado's favor. Why would we not put the public interest factor in favor of the state when this was passed by a duly elected body of legislators, Federico asked? Because it conflicts with the United States Constitution and the Supreme Court decision of the Bruen, which was prerequisited by the Heller decision. All of these things are going towards the ultimate culmination of defeat for gun controllers. But now they've got their judges, Obama and Clinton appointee, and now a Biden appointee, saying, well, why can't we just talk about, the legislature's passed it. Really? You want to go down that road with no checks and balances because the legislature's passed it? Okay, now let's actually address the actual thing that he just said. Yeah, that's called interest balancing. The Bruen decision completely got rid of the ability for a court to interest balance. That means the rights of the public safety trump the rights of the individual from Second Amendment, so therefore the Second Amendment can go away or get infringed because of the rights of public safety. That's what that argument is. But the Bruen decision destroyed it. So they are arguing for racism, abject stupidity with 5-year-olds purchasing guns, and now old, retired, and overruled arguments that the judiciary has been putting forward from the left for the last 20 to 30 years. This is one of the dumbest things that I've seen in a hot minute. Let me know what you guys think in the comments below, and I will see you on the next one. I'm Braden. See you later.